down this judgment in this matter of Max Chris against Shabangu Joyce in the following manner. It is not going to be a judgment in the sense that we understand judgment as in to analyze the law, facts, arrive at a conclusion, and therefore hand down or grant an order. And Mr. Mashangu, you're going to be disappointed because you're probably looking forward to your cost order, the bonus appropriate. But we are not going to do that at all. What we're going to do is to evaluate what we have seen in a positive light. You know, we are all learning here. So the idea is not to break people, but equally the idea is to be as honest and as open as possible so that we remediate and we improve. And I take it that's the purpose of the exercise. So what we're going to do is to allocate points on the following items. We'll start off with the applicant's written argument, what we think of it and how much scoring should go to 8 out of 10. And then we'll deal with respondents' written submissions and we'll similarly award points to that out of 10. We will then deal with your individual presentation styles and award points here. And it's all positive for you. It's all in a positive light. The organizers have asked us to do that, so we have to do that. But we want to start off by thanking you for your preparation, which is really, really thorough and quite impressive. But in order to make sure that our evaluation of your performance is fair, we have to understand your experience and where you come from, because the bar has to be at the requisite level. It's no use evaluating you as though you were a senior counsel or chief justices indeed, when in fact you're still. So we have to evaluate your performance at the requisite level. I'm going to start with you, Ms. Wolf, again. I beg your pardon? The question is, are you a student? Are you a practicing attorney? At what level should we evaluate your performance?
I'm a third-year student at the University of South.
Right. And Mr. Ali?
I'm a third-year postgraduate student.
Where?
Seen this very well.
And Ms. Mutumi?
Justice, I am a Judges Registrar at the Lakefield School.
Oh,
Graduated last year.
so you've had the benefit of seeing counsel in court, so the bar is going to be elevated. In your case, you see how helpful this is. All right. Just as a matter of interest, how do judges in the Labour Land Claims Court, how are they addressed, as justices or as my lord and my lady?
According to the practice direction, they're supposed to be addressed as justices, but I've seen advocates, counsel address our judges as judges, or sometimes your honor or your name. It doesn't have a standard practice in case.
But in terms of the practice direction, it's just the same as the SCA and the Constitutional Court.
Yes,
Justice Nkosi-Thomas or Chief Justice,
No, not Chief Justice, just all of them are justice, they're all in the same standing.
Is that right?
Yes.
Do you have a JP there? Or what is
We
it?
have an acting judge president. Since Judge Byrne died a few weeks ago, we haven't really filled the position.
So it's justices, that's
It's justices.
the convention. And Mr. Mashango?
I'm a law student at the University of South Africa in my third year.
And do you have any court experience?
No.
Where did you get this idea about costs?
About?
The costs, the cost order that you saw. Where did you get that idea?
Through procedure module, but also I did a law student competition earlier this year called Mod Code. Well, yeah, I think they have it at Lake University, but I was participant there, the Mod Code.
Thank you.
Bar goes up for him too.
It's a law student competition.
I mean, the person who's really in trouble is Ms. Matume. Yes. All right. So we've considered your written submissions, so coming out to your side. And as a general comment, our view is that the written submissions, from both sides, are well researched. You understood what the case was about, but both sides went quite clear in terms of what your course of action is. Is this case about, are you seeking an interim interdict? In which case, what are the requirements of an interim interdict? And one would have expected that would have been set out up front. Or just looking at the submissions, can it be said that what is being sought is a final interdict? Where are the requirements? We could not see that. That didn't come out, didn't emerge clearly from the written submissions. Are you seeking a declarator that the comments complained about are defamatory and a consequential relief upon that declarator for the removal of the post from tweet? It's by no means clear what's been sought. Or is this a damages claim proper and the relief sought is an apology? It wasn't clear. So it made the job of the court all the more harder because we had to find out from this maze of facts and law thrown at us what in fact is the relief that's been sought. So by way of a suggestion, we suggest that going forward you have to be clear as counsel what relief it is you are seeking and state that upfront. This case is about an interim interdict. The applicant seeks an interim interdict in the following terms. These are the facts that lead to, on the basis of which the relief is sought, the law. These are the requirements of an interim interdict. You set them out. Then you apply your facts and your law to the various requisites. A clear right, harm, no alternative relief. Then you package your heads accordingly. In that way it becomes logical. Your judges are able to follow clearly, understand what the case is about, what law applies, which facts are you relying on, and then the conclusion becomes, just follows. It's logical. It leads you there, it takes you home. But we found that the written submissions, with respect, were all over the place, despite being well researched. But they were not logical in that sense. And that applies to your side as well. And perhaps because you are acting for the respondents, you didn't know what case it is you were called upon to meet because the submissions were all over the place. Maybe that's what it was, but you should have told us so when you rose, that it's by no means clear what my client is supposed to answer to. Because on the one hand, there's defamation, there's this. You should have complained and made that point clear. So you went ahead and you defended a case that was not clear. Then we asked you, Ms. Madum, is this an interlocutory interdict or a final interdict? And that's when you started saying, I don't know, maybe you're asking the wrong person, but you are here. You're arguing. What are you defending your client against? So that's what you should have said up front, that it's unclear. But we assume that this is what is being sought, but it's by no means clear from the papers, and then we run with it. So that is just a general comment on the written submissions. But otherwise, we found, as we were deliberating, we also view that well researched. But it's more the packaging, it's a bit confusing. It's not logically presented. So that's something to please keep in mind going forward. Now, in terms of scoring, the applicants, out of 10, the team decided on 5.5. That gives you a 55%. It's a good well, we've taken into account your experience and everything, and that's where we decided to score you. On the other hand, the respondents, we had, before we heard of Ms. Matume's experience, we had decided on a 6.5, which is a 65%, but we have to discount 5%, not 5%, to 0.5. Yes, because of the experience. Come on, we've seen heads of argument before.
But then I contend that I only recently started working at the Lakers. I also want to
When did you start?
I started in June. And even if I was dealing with the administrative side of things, so I never got the opportunity to go through files properly, the heads and everything. I only started recently.
Therefore,
just
regarding heads to your representation, we shall reinstate the 0.5, so the points will remain at 6.5, which gives you 65%. Well done to teams. I am now going to ask my colleagues to deal with the individual participants. I'll ask Justice Dauds to deal with Ms. Mkosi.
Yeah, thanks. Ms. Mkosi, in this game you're selling your... No, sit down, no problem. In this game you're selling presentation, you're selling time. And through that, you market yourself. You kind of brand yourself. You want to stand out. And so your performance in court does matter. And so you're never going to read your arguments to a court. And understandably, that comes from being a bit nervous. But there has to come a time when you put it down. And rather sooner than later. Because you're supposed to know your case. And incidentally, I gave you that card there. Does the card not say something about thorough knowledge of the law and doing a rigorous analysis of the legal materials? That little thing, that love letter, love note I sent you, I gave all of you. Oh, that's it. You need to know your case back to front, in your sleep, so that you won't need a note to read from. So initially when you did that, I was perturbed, but then after I corrected you, you got into the flow of things. So, but you did well. I must say, once you were told, put it down, you did pretty well, you know, and that's what arguing on your feet is all about. And admittedly, you were the icebreaker for everybody. So you felt the butterflies most. By the time the others got up to speak, address the court, you had already broken the ice for them. So one must grant you that leeway. But I must say you did pretty well once you got into the flow of things. Your junior, Mr. Ali, you did pretty well. You handled the questions, the presentation well. But one must also admit that by then you had the benefit of her having broken the ice for you. So there were no longer any of those butterflies that she had to go through. But it was really well done. I like your presentation. Ms. Batome, the court kind of took umbrage to you calling the court arrogant, impertinent, audacious, brazen. And you did that by using the word presumptuous. That's what presumptuous means, brazen, impertinent, arrogant, audacious. Why did you do that? You're starting off on the wrong foot. You know, how dare you accuse the court of that when the court hasn't even started deliberating this matter? You know, so the language is important. Don't say or do anything that might upset a court. The judges are only human. They also take offense. So be on your guard for that. But you delivered a good presentation. But you need to learn to argue more on your feet and stop being ambivalent. Right? And that comes from, again, knowing your case inside out. Having done a rigorous analysis of the legal materials that were presented to you in preparation of this case. And you were ambivalent when you were asked, what is the nature of the application? Is it interlocutory? Is it final? You were dancing around hoping that somebody or something might come to your rescue, and then you try to shirk your responsibility by saying, ask the others. No, you can't do that. They'll get their turn, but when we're busy with you, you need to be quite firm on what exactly it is. Again, it comes from knowing your case inside out. If you knew your case inside out, you would not have made that mistake. So much longer, again, just like Mr. Ali, very good presentation, but the ladies by then had broken the ice for you guys, you know. So you got the easy part of it, nicely. And you became so audacious that you started asking for cost they bonus appropriate, you know. But overall, it was a very good delivery. I'm impressed with that side's delivery as well as this side's delivery.
Thank you. And I'll get my colleague to talk to the oral argument and also deal with the scoring.
We want to thank you all for the submissions that you made. In terms of the scoring, we've already gone through Ms. Muffer-King, have we?
No.
So Ms. Muffer-King, having regard to all the points that Justice Dauds and the Chief Justice has raised, we've scored you 2.5 out of 5. That is out of 5. Mr. Ali, also a 2.5 out of 5, having regard to your experience, obviously, and the fact that Ms. Muffer-King did do the opening argument, and you had the benefit of that. Ms. Matume and Mr. Mahlangu, we've awarded you 4 out of 5 each. We believe, obviously, well, I don't know, we might have to revise Ms. Matume's score again. But, so both teams, your total score would be 5 out of 10 for the applicant's team and 8 out of 10 for the respondent's team. Both teams were very confident for your level, and we thank you for your participation.
It is so ordered. That is the order of this court.